talking, sir. Don't
I know.
be rude. Can I
I
just
am not being
finish my
rude, but I'm
sentence?
trying to keep control of this committee.
I understand.
That
but
would
when
not
you
be accepted
interrupt
because
me-
it would be directed to the,
Okay.
the keeper of the records.
Okay, so let me finish my sentence.
I'm trying, go ahead.
So basically, we've established here that if someone brings in a request to a county employee and drops it off, and it's not, they didn't drop it off to the custodian of records, in this case it's Mark Hedrick, right, county clerk, then every department is responsible for making sure that request gets to the right person. Is that correct?
Correct.
Okay.
Which would be
And responded to within 3 days.
And responded to within 3 days as per the statute.
Right.
Okay, I got that. Now, this thing about the deposit, I don't think the statute allows you to do that.
Well, that's something I think we're gonna talk with our
Yeah, we'll have legal
to see
Yeah.
if
counsel
we can do that.
adopted.
Who's the legal counsel?
Travis Elliott.
Travis
With
Elliott.
Missouri Association of Counties,
Okay.
with the state, he's a state advisor.
Because I think what the statute says is that anyone who requests can ask for an estimate of the fees in advance, which would certainly save you all a lot of time, because I got the sense from listening to you that if you determine that a request is vague, that perhaps the better course of action would be to reject it or communicate rather than doing all of that work and then complaining about having to do all of that work because the request was vague. You get what I'm saying?
It was my recommendation to just communicate with the requester.
Yeah, it makes
And that it would avoid all the headache on both parties, is where we're pulling documents that aren't gonna be paid for, and the requester is getting 800 pages of unwanted information.
Right, so
reach out and clarify before anything's even done.
okay. So when you reach out to people, if you examine the request, or the clerk, who's responsible for reviewing the request?
The clerk, I think, is just responsible for accepting the request, and then he was, I think, by statute, responsible for certifying the records before they're distributed.
So who determines if the request is vague?
It would be whoever, in my opinion, again, this is something
Would be
that the
whomever
commission
was
would have to look into, but in my opinion, it would be whoever's office the information pertains to. So if it's copies of checks, that would be the county treasurer, and if she didn't think that there was enough information there, she could reach out to the requester and say, I'm confused by your letter, are you wanting all of this, or do you want just like this? Or say it was copy of credit card statements, and the specific credit card statement you were asking for didn't exist, but instead of saying those records don't exist, you're gonna have to file another request, we could say, well, that specific credit card doesn't exist, but this credit card exists, would you like those statements instead?
Okay.
And then they could say, yes, well, actually I would. Okay, it's gonna be about this many pages for this many years, which makes it gonna be about $25.
Okay.
So that makes you aware before I start pulling information,
Right.
and that makes sure that, we're not giving you information you don't want.
Right. And I understand that. I think that's an excellent idea. I just don't think the statute allows you to force people to pay.
We'll learn that, man.
Gosh, would you please, sir, stop interrupting me?
Listen, you're welcome to sit here and you can answer questions, but you have to.
It's open comment. You asked me to if I had questions.
Yes, ma'am, but
and I'm talking, but you keep interrupting me.
And
you
you
don't
keep
want
interrupting
me to
the
say
committee.
anything. Was I interrupting you, Ms. Mangilette?
No, but I have a comment too. We'll learn what's permitted and what's not through our legal legal counsel.
I'm going to ask this question, if I'm allowed to finish a sentence. What is the procedural policy for allowing people to comment and ask questions? Is the policy that the presiding committee member interrupt everybody at any time and refuse to let them talk? Is that the policy? Because I need to understand this, because I want to get through this, but I mean, I was not raised by wolves. I was told that it's impolite to interrupt people and it interferes with communication. So I'd like to be able to communicate. I'm not here to fight, but it is terribly rude and against my upbringing to have to put up with the constant interruptions. I don't think that we will be here very long if I'm just allowed to finish my sentences.
No problem. Anything else for the policy?
I still have questions.
Okay. Go ahead.
Okay. All right. So, I did not hear anywhere any notification to the requester of the right to dispute the fees under the statute. Because the statute does allow a person to request a waiver of fees if the request is in the public interest. And I don't think that that is something that people are frequently informed of, but that they should be.
And you can add that in our little, in the body down here.
All right,
Do you know what statute number it is exactly? I know we say at the bottom of the form that the St. Francis County Commission shall comply with the sections 610.010, 610.030.
Right.
But I don't know if it's included in one of those. We can specifically list it if you think that would be more clear.
Oh, it's specifically part of the statute itself.
No, I'm saying I understand that we can specifically list it in our policy to make it clear.
Okay, so then I can probably pull it. I think I circled this. This is several pages long. But that brings me to my next thing, which is if someone requests a waiver of fees because their request is in the public interest, who makes the determination to deny the request, and then what is the appeal process from that point on?
That I don't think so.
I think that'll be determined by our legal advisor.
Okay. So Ms. Mengilette, will you ask him?
I should put that. I'll put that in.
Okay. Which brings me to my next thing.
And that may have been something we may have said we need to list in there anyway, is something about the appeal process. I'm not sure.
I think that is something that.
Did you know this one yet?
I have not.
No, okay.
No, he hasn't looked at this at all. I figured it was better
Well, again,
use of money to not.
he made a suggestion, and I think Louis was in on the conversation where office holders, it's gonna be directed to the county clerk, that office holders still need to sign off so that they are all made aware of the
So
policy.
you think not only the county clerk
You can
needs to
ask
sign,
him
but the
about-
actual office holder? you
Right.
think? Okay.
You can ask him about it, see how that needs to be set up, but
Okay.
to make sure everyone is aware, and we wanna make sure we fulfill or
Sure.
make available any request for record.
Okay.
So just the office that it pertains to?
You can, talk with him about it, and see
Okay.
how he wants it worded, but
I question the need under the statute for this form, this requester having to acknowledge this. I think that the statute provides all that is needed for someone to request records, and they even include the language that a person should use. I don't think that there's any requirement that they be bound to sign any additional documents.
Is there a question in there?
I was getting there until you interrupted me. So, what I'm asking you is, how does someone who maybe does not live in this county and, like this lady here, does not have access to a computer, get hold of this form, and why is it necessary in the first place when the Sunshine Law provides a request form verbatim?
Well, this isn't necessarily saying how you need to provide, like the language you need to put in your request. I think the original resolution was to state in writing what the county stands on for charging fees. It says, per statute, they can there should appoint a custodian of records. You can charge up to 10 cents per page. I think the resolution was to put in writing what the county's policy will be. That the county clerk will be the custodian of records, and we will charge 10 cents per page for copies. We will charge for research time. Like you said, there is a waiver in there that, they can request the waiver, but I think it was standard procedure to standardize everything, that to acknowledge the county was going to charge 10 cents per page, and the county clerk is the custodian of records.
Again, this is a starting point to develop the policy, and it'll have to be legally reviewed, and probably suggestions that we'll need to gain another meeting to review that before it's adopted.
And it may not be something we actually have the requester sign. It's more along the lines of notifying the requester up front what the county's policy is on the Sunshine Law.
Okay.
meaning that the custodian of records is the custodian of
So
records.
let me ask you this, why even have a policy when you can just resolve to follow the sunshine law? Because I think pretty much everything that you're talking about is in the law itself.
Well, it says you may charge up to 10 cents per page. It doesn't say you have to, so it's up
Right.
to, like it would be at the county commission's discretion if we are gonna charge 10 cents per page or not. So I think what this resolution was to say is, we are charging 10 cents per page
And
for
the
every
resolution
sunshine
just
law
is gonna be
request.
part of the policy too. But the policy is so that we're all doing the same thing consistently throughout the county
Right.
toward that. So it's an operating policy more than whatever it is. But again, this is the first draft of anything, so.
Well, and in my opinion, I think it would make it more standardized and more equal, so that if you were to come in and ask for a copy of my paycheck, and, we charge you 10 cents for that, and then Ms. Carricker comes in and asks for a copy of my paycheck, and we say, you know what, we're just not gonna charge you. Is that fair to every taxpayer? I
I don't think it's fair.
I think everybody should be charged the same amount for the same records over and over again. I don't think it should be any preferential. Now, maybe there should be something in there about a waiver. Somebody can request a waiver, and if the commission were to vote on that, everybody has that opportunity.
Does the commission have to vote on that?
I would think if it's their policy to charge, that it would be up to their discretion to waive fees if they chose to.
Well, this is my question on that. If the statute says that a person can request documents because they're in the public interest, and a waiver applies if documents are requested because they're in the public interest, how do you determine that they're not?
Well, I think that's why it's up to the commission to decide, because I think any individual office holder really, and this is just my opinion, I don't know, wouldn't have the authority to say if that could be waived or not. I mean,
I'm wondering if that's really something that should be addressed in litigation
Sure.
rather than through the
That would
commissioners.
be a good question.
and that is something, we could do, maybe
Whether or not to put
send
it
it to him and get a letter in writing saying yes or no, and that could be something we could put in there.
Any other questions about this?
I just wanna make it, when we say that the county clerk is the custodian of records, that doesn't mean he has all the records in his possession. He's gonna have to work with other offices in order to develop any sunshine law request, depending on which office has those records.